Good evening to everybody. And today topic is the strict construction of the penal statutes. A clear language is needed to create a crime, and a statute enacting an offence of imposing penalty is strictly construed. That is observed in the Shamsundar versus State of Haryana. A statute providing the penal prosecution has to be constructed strictly. However, this rule is not of the universal application, which must necessarily be observed in every case. Chief Inspector of Mines versus Karamchand Thapar, it is stated. Let me see the one of the case law, that is the virtual soft system commissioner versus Commissioner of Income Tax. In this case, it was observed that Section 271 of Income Tax Act 1961 is a penal provision, and there are well-established principles for the interpretation of such a penal provision. Such a provision has to be construed strictly and narrowly and not widely, or with the object of advancing the object and intention of the legislature. The statute creating the penalty is the first and the last consideration and must be construed within the term and language of the particular statute. Where an ambiguity exists and it has not been possible for the legislature to express itself clearly, the court exhibits a preference for the liberty of the subject and resolve the doubt in favor of the subject. Let us see another case law, that is W.H. King versus Republic of India. In this case, it was observed that a statute which creates an offence and imposes a penalty of fine and imprisonment must be construed strictly in favor of the subject. The principle that no person can be put in peril of his life and liberty and an ambiguity is well established. To put it in other words, the rule of strict construction requires that the language of statute should be construed that no case shall be fall within it which does not come within the reasonable interpretation of the statute. The penal provisions should be construed as a manner will suppress the mischief and advance the object which the legislature had viewed. That is observed in the Lalita Janan versus Bombay Gas Company. The provision of the penal statute can't be presumed to have a retrospective operations. And let me see when the two interpretations comes over there, how we have to choose which one. When there are two possible constructions, the court must learn towards the construction which exempt the object from penalty rather than the one which imposes the penalty. It is not competent to the court to stretch the meaning of an expression used by the legislature in order to carry out the intention of the legislature. That is observed in the Tularam Relumar versus State of Mumbai. The effect of the rule of the strict construction might almost be summed up in the remark that where an equivocal word and ambiguous sentences leaves an unreasonable doubt of its meaning, would the canons of the interpretation fail to resolve. The benefit of the doubt should be given to the subject and against the legislature which has failed to explain itself. And let us see the another screen and how it will be applicable. Then we see the strict connection of the penal statutes. We follow these principles also. In the interpretation of the penal statute, there would be a strict construction occurs when ambiguous language is given its exact and technical meaning, and no other equitable considerations or reasonable implications are made. Let we see that let the 99 innocent will be acquitted, but one innocent could not be convicted. Based on this principle, the criminal or penal statute should be construed strictly. And if you see the further examples in the form of case law is concerned, according to Lord Isher, the settled rule of the construction of the penal section is that if there is a reasonable interpretation which will avoid the penalty in any particular case, we must adopt that construction. If there are two reasonable constructions, we must give the more lenient one. I repeat, if there are two reasonable constructions, we must give the more lenient to the lenient one. Interpretation of penal provision must be in consonance with the principle underlying the fundamental rights. Any provision which visits an accused with the adverse consequences without affording any remedy or disprove the item of evidence which stands against him innocence is inconsistent with the philosophy enshrined. In Article 21, it was held by the Supreme Court that they should so interpret such a provision as to dilute it to make it amenable to the Article 21 of the Constitution. Let me see some of the case laws, how it can be made. Yes, in one of the House of Lords case law, in one of the English case law, House of Lords held that consensual sadomasochistic homosexual encounter which occasioned actual bodily harm to the victim were assault, occasioning actual bodily harm contrary to the section 47 of the Offences Against the Person Act of 1861 and unlawful wounding contrary to the section 20 of the Act, notwithstanding the victim consent to the acts inflicted on him. The following are some of the propositions important in relation to the construction of penal statutes are concerned. A. If the scope of the prohibited words cover only some class of persons or some well-defined activity, their scope cannot be extended to cover more on consideration of the policy or object of the statute. And the B. The prohibitory words can be widely construed only if indicated in the statute. On the other hand, if after full consideration no indication is found, the benefit of the construction will be given to the subject. And C. If the prohibitory words in their own significance bear wider meaning, which also fit in with the object of policy of the statute. And there are some of the cases are given over there, but let me see the case law of Sweet versus Parsley case law, where the House of Lords said a school teacher let her house let her let her house out let out for the students. The students were smoking cannabis in the house. She was unaware of the activity. She was charged with an offence of becoming a concern with the management of the premises which were being used for the purpose of smoking the cannabis, contrary to the section 5 subsection 6 of the Dangerous Drugs Act 1965. The statute did not state any requirement of the mens rea of the offence. The House of Lords held looked at the common law before the statute was made. The common law required the knowledge of the activity in order to impose the liability. Thus, the presumption that the statute don't change the common law was applied in addition to the presumption that mens rea is required where the offence is a true crime as opposed to a regulatory offence. That means landlord did not have knowledge regarding the use of cannabis in her premises. Hence, the offence should not be extended to the owner of the premises and the criminal statute. That's the reason the criminal statute has to be construed strictly. And let me see the Rima Agrawal versus Anupam Agrawal case law. A broader meaning was attributed to the application of the section 304B and 498A of the Indian Penal Code. In the light of the broader purpose which was sought to be achieved through these provisions, and the mischief was required to be cured. It was also made applicable to the case where the legitimacy of the marriage itself was in question to bring the accused within the purview of the word husband as used in the said provision is not proper in construction of penal statute. Hence, that person could not come under the purview of the husband. What it means, when the marriage itself is questioned, it is not proved over there, and there is no question of husband will come over there. Hence, it should not be extended. The word extension should not be made to the husband when marriage itself is not proved over there. Let me make the conclusion in this way. After the detailed analysis of the various cases and methods of interpreting the penal statutes in this presentation or in this lecture, we can broadly categorize the method of interpretation by concluding that firstly the basic rule of interpreting such laws is to strictly adhere to the language of the statute, since it is the will of the legislature and the court should restrain itself from the stretching the meaning of the word, causing unnecessary hardship to the subject. Secondly, it must be always kept in mind that what is the purpose of or which the enactment seeks to achieve, and if a strict adherence is done, it will be able to achieve the purpose or object. Thirdly and lastly, whether by such an interpretation the mischief which was sought to be suppressed by the penal law was supposed and not, then it is the duty of the court to ensure that it is done, and just because of the legislature omission or injustice to the society should not be administered. That is the end of the today's lecture. Thank you very much and bye.